Bonjour, bon après-midi, mesdames, messieurs. Bienvenue à cette conférence organisée par le Centre de recherche en droit public ainsi que le laboratoire de cyberjustice. Je me présente pour les gens en ligne parce que dans la salle, je connais tout le monde, mais en ligne, si je ne vous connais pas, mon nom est Nicolas Vermez, je suis le directeur du Centre de recherche en droit public, directeur adjoint du laboratoire. Il me fait plaisir de vous accueillir à cette activité. I will switch to English simply because our lecturer will be presenting in English. It is my great pleasure tonight, or this afternoon rather, to welcome a dear friend, Justice or former Justice Dory Reiling. Dory was the senior judge of the Amsterdam District Court until she retired in 2018. Before that, she was a senior judicial reform specialist at the World Bank and an IT program manager for the Netherlands judiciary. And she was also actively involved in designing and building digital procedures for the civil courts in the Netherlands. She is currently, even though officially retired, but we discussed this and I don't think she quite understands what that word means. She is currently the lead reporter on the European Law Institute's project for digitalization of civil justice in Europe. She is a brilliant mind on court technology, somebody I've had the pleasure of discussing these matters with over the years and hearing on these topics. And so when I became director of the CRDP, I said I finally have the power to invite her to come and speak with us in Montreal. She will talk to us today about her experience in the Netherlands, how she led the reform there of the courts to move towards a more technological handling of court information, court documents, and all of the issues that you can imagine happened along the way. So without further ado, I will cede the floor to Dory. And once again, thank you so much for accepting our invitation to join us today.
Well, thank you, Nicola, for the invitation. It's my first time to be here in Montreal, and I'm really excited to see all of you here to come and listen to some of the things I'm going to tell you about. When Nicholas asked me, he said, could you talk about IT in the courts in the Netherlands? Because some interesting things happened there. And so I thought that was an interesting challenge. So I started thinking about what I was going to tell you, and then I realized that it was actually a very personal history. So I decided to just make it a personal history. Talk about how I got involved in IT, my thoughts about it, how they evolved over the years, what we've done, and what ultimately happened in the Netherlands. So let's see. This is just for your information. It'll be in the presentation. So you will know where to find me if you want. So when we talk about digitalization, what do we mean? We move digitalization in an organization means that you move this organization from traditional paper-based processes to processes supported and replaced by digital technologies. I mean, I'm very precise about definition, so that's why let's start here. So we change products and processes in order to improve the value that we deliver. Here it says effectiveness, efficiency, and timeliness. Right now, I think if we talk about justice values, I would rather talk about fair hearing and access to justice and similar sort of values, but I'm coming back to that later. So, okay, this is about digitalization. So now, a little personal history. This is 1986. That was the year that I became a judge in the court in Alkmaar. And in 1993, so 6 years later, I became a senior judge, or what was then a small claims judge, which is a promotion in the Netherlands, in the court in Amsterdam. And I've been in the court in Amsterdam ever since, though I spent a lot of time in other places, as you will see. So that was 1986. But actually, my history with technology starts in about 1982. I was doing an internship with the Council for Building Arbitration, and they had huge machines that could produce documents. was the first time I saw technology at that level, and I thought, oh my God, this is going to be very helpful for courts and judiciaries to improve the way they work. So that's where it started. So by 1986, I became a judge in the court in Alkmaar, and from day one, we started, the back office had one personal computer at the time. And so we started figuring out how we could use that one personal computer to improve what the back office was doing. So making standardized documents and things like that. There was no network, no database with data yet, but that came soon enough, because when I went to Amsterdam, the Amsterdam court already had a network with a data that you could access and you could use to compose your documents. So that was a big step up. We started experimenting with producing court decisions using the database and standard documents, and it was a big step forward. And that became an example of what later became a nationwide tool to actually compose judgments. So let's see what else. I have to, this is my notes, so I have to keep looking at them, even though of course I know what's in them. So in the 90s, the Netherlands judiciary began to realize that they needed to think about how to use technology, and they set up a committee. And I was on the committee from day one. I think so, we're in the middle of the 90s. And in 98, I became its president for a very specific reason, because this was the time when the governance of the Netherlands judiciary was going to change. We were going to get a judicial council instead of being run by the Ministry of Justice. And the Judicial Council needed a policy plan for using technology. And so my job then was to produce that plan. We did a lot of consultations, and I had a couple of consultants helping me. And this is actually the result. This is the cover of the plan that we made. I presented it to the court presidents, I think early in 2000, in the year 2000, or maybe just before. And what it says, what I thought was important is to focus not on the technology. What can it do? You can make technology, even then you could make it do nearly everything. But what is important is what you want to use it for. Improving your processes, so things can maybe go faster, or people have better access to the information that they need, things like that. So this was the example of what we thought should be done in the first 5 years. And when the plan was done, I was headhunted by the World Bank, who said, oh, if you can do a policy plan like that, we need someone who can do that for our work, because we give a lot of money to developing countries who need to reform their judiciaries. They buy hardware, and then the hardware just sits there and nobody knows what to do with it. So we would like to have someone make a plan for that. That's what they hired me for. I don't think the plan really ever materialized in the shape that they wanted at the time. Things sometimes change very quickly in organizations like the World Bank. But I did spend 3.5 years there. I learned an awful lot. So here, this is in Africa, where I did negotiations with the Ministry of Justice about a plan for reforming judiciary in a very broad sense. So not just technology, but very broad. And what the World Bank then does is to make a budget to give the government of, in this case, Benin, a budget to carry out those reforms. And we then do the evaluations of that. So here we are. But in 2007, my contract ended, and I decided that it was time to go back to judging. I hadn't done any judging for 10 years, and I thought it might be nice to do a little more. So, but I thought, I know myself, in about 3 years' time, I will get bored again if I just do cases. So I had a conversation with my former boss in the Judicial Council, and he said, really, we would like you to share the knowledge that you've gained at the World Bank with us. And I said, well, I would like to do a PhD. So we turned that into a project. So that was 2 years later, that was my PhD. And that's the orange book, right? The one that you see here. It's called Technology for Judicial Reform. And the choice I made there was to not discuss primarily the technology, but again, to say, okay, what are the three biggest complaints from court users? And of course, I learned a lot about that while my time at the bank. The biggest problems that people complain about are things take too long, there's no access, and the judges are corrupt. So I took those three themes and discussed each of them. What do we know about these themes? What are the information aspects of them? And what does that mean for the kind of technology that can help reduce delay, improve access to justice, and reduce corruption? So that's the book. And if you think, hey, that might be interesting, there's a free PDF on my website. There's a free PDF on academia, my academia page, on my ResearchGate page, and in a lot of other places, like my publisher's page has one. So free copy, or if you're interested. What happened next? Well, I went back to court, but before we do that, some findings from the book, and I have to take a look here to see if I get that right. One of the things I did in the book, I had no intention of actually doing. Why not? Because I was going to talk about those problems. But my colleagues in the court said, well, we don't understand why technology in courts is so difficult. So I thought, well, if that's the problem that they're working on, I think I'd better study it. So I rescheduled my plan to actually include that topic also. So there's part 2, chapter 2.2 particularly, is an analysis of evaluations of technology projects in courts and also elsewhere to see what goes wrong and what you can learn from that. Now, the two projects that I learned from was the HBS project, that is a project in the Netherlands, that was bound to fail, clearly from the start. And after 3 years, I personally set about killing that project because it wasn't going anywhere. The other one is the Ontario Integrated Justice Project. That was, at the time, that was a very famous project that also failed spectacularly. But we learn more from our mistakes than from what goes well. So learning from your mistakes is really important here. That was the point. And one of the, some important lessons here. There needs to be a strategic alignment between the IT and the organization's business. Now, clearly, if your problem is that your users think things take too long, that is something that you have to deal with, and you can use technology doing it. That's the thinking behind that. But your vision on what your business is, and in the case of courts, it is delivering justice, that is leading. So delivering justice is leading for the choices, technology choices that you make. And of course, we have to ask ourselves, what are we here for? And my conclusions were that judiciaries used to, shifting paper from one side of the desk to the other, they are, in a sense, excuse me for saying this, they are, in a sense, factories. They are a production line. And if you are a production line and you have very, very limited resources to actually do experimentation, then it becomes very difficult, as we shall see later on. So the other thing you need to do is be ready to do experimentation. And what happens when you do an experiment? You try something, and if it doesn't work, you try something else. So 9 times out of 10, your experiment isn't going to work, which is normal. But lawyers don't think that way. I don't know about you, but the lawyers I know, if something goes wrong, something happens, and then we turn around and something's gone wrong, and the thing we want to do, our first thought is, who can we blame, who can pay, and who's going to pay the damages. So, but this is an attitude that doesn't help if you need to innovate by doing experiments. So that makes life there hard there. The other thing is that you really need to have in-house knowledge, because you cannot expect technology experts from outside to understand exactly what it is that you're doing. So you need to have people in-house who do, judges who understand technology, technologists who have worked for the judiciary long enough so they understand what the processes are and what they're supposed to deliver. And the last one, simplification. Now that's another difficult one because we lawyers tend to focus very much on exceptions and details. But that can have very lethal results, as we shall also see later on. So this was my idea in 2009 when I wrote the book. If there are any questions, by the way, please intervene. Raise your hand, because that's always the best time to discuss something. Now, this picture was taken, of course, in 2011 in Strasbourg at the Council of Europe. The Council of Europe is the owner of the European Convention on Human Rights. And they have several bodies there, judicial bodies, legal bodies that work for the council, the convention. This is a meeting of the Consultative Council of European Judges. They produce an opinion every year about a topic that is relevant for judiciary. So in 2011, they hired me as an expert to compose opinion 14. That is the first opinion about technology for judiciary. And I must admit, I'm quite proud of the end result, because the basic thought is that judiciaries welcome technology as a means to improve how they work, and that it may also involve changing your governance. Those are two very big steps for judiciaries to take. So that's opinion 14. Last year, opinion 26 is the second opinion about information technology. Very different, but also it builds on opinion 14 as well. It might be interesting. They discuss a little bit more about artificial intelligence. So opinion 14, that was 2011. And then the Judicial Council came back to me and said, yeah, well, we're going to do this huge program. We're going to digitalize the entire court system in 3 years, and we would like you to do the civil justice. And I couldn't help myself, and I said yes right away, because I thought this would be the proof of the pudding. So what you see here is my team. We worked on this for 5 years, and I'll show you what we produced a little later on. And this was the day when we had the whole system working for the first time. So we were really proud of that. Let's go to the next one and see. Yeah, because here it is. This one, this does not work as an animation. So if you start digitalizing a court procedure, where do you get your requirement? Well, the first one is your procedural legislation. That is basically your process description at a fairly high abstract level. And then you have practice regulations made by the courts or by whoever in your national system makes the practice regulations. Then the next step down is to do work process design. So from those regulations, you say, okay, what does that mean? It means that so-and-so has to do this and role that has to do. So that's the work process design. And then you have the project brief. That is the idea that what you get from your principal, what they would like to see, and that doesn't, let's say that they don't always tell you the same thing, which makes life interesting. So, and then you have the technology. And of course, coding has its own rules, and depending on what technology you use, there are certain things that need to be done in a certain way. Those are the most interesting questions, where there is the conflict between either your project brief and the technology, or the procedural law and your technology, and how do you deal with that? So that I had a 15-man person design team to crack things like that. And we're coming back to the procedure itself. So these are the main aims that you have to go for. So again, realizing the values that are actually in the convention: access to justice, fairness, public trust, timeliness, and impartiality. So again, these are the things that have to be translated into the things over there. And together, yeah, they will hopefully produce a procedure that will deliver value for the users. The methodology we used is agile design. That has by now become more or less the standard methodology. But when we started doing this in 2012, it was still quite experimental, and it was unusual for courts to do this. But I was a big fan of it. I felt very comfortable using this methodology. And here you see me and my assistant working on the calendars that we had. We had enormous boards like that, where every detail had its own place, and it moved through time and also through the design to see. So we could see what we were doing, and everybody else could too. So this is very the best way to manage a project like this is to make sure that everybody can see what's going on. And the standard methodology in agile design is that you first define a minimal viable product. That is the smallest, let's say, process that you can design that you need to make to work. So we had long discussions about what our MVP actually was, but I'll show you what it is in the next slide, because here we're going to build the procedure from the start. So of course, for a court procedure, one thing you have to do is you have to have a case. So this is a lawyer. Why a lawyer? Because lawyers are about the only professional group who have a digital identification that is good enough to communicate with the court securely. At least in most countries in Europe, it's like that. So here we have a lawyer filing a case. And the system needs to be able to deal with the information that the lawyer has filed, turn that into a case file. Case gets a number, and the lawyer gets a URL back for the case file, so she can access the case file. That's essential. And what the system also needs to do is to give a task to check the filing to someone in the back office in the court. So that is, we had long discussions whether that was a necessity, but the court people said it was, so there it is. The other thing that needs to happen is that the other party, the defending party, needs to be notified. Now, I'm going to keep it simple for now. Notification, coming back to that later as well. And so, in the administration, let's say if there's no defense from the defending party, then we have a default case, and in Dutch law that means that you can give a default decision. So we decided that was the MVP. The decision is drafted, finalized and then sent back to, in this case, the lawyer, and both parties then get the decision. This is the minimal thing you have to do, and this is already quite complicated because it involves HTML for the web portal. It involves database technology in the court back office. It involves document production, instant messaging, and so. But this is how we started. So we built that. And as soon as we had it up and running, from let's say after 2 weeks, we had this up and running, and we got lawyers and people from the courts in to actually test whether they work properly. And this is another thing you have to really do in Agile. You have to make sure that you test everything as soon as it's working. Of course, the opposite is waterfall development, where you make a complete project brief, then you give that to the people who have to build it. They build a complete system, and then you see if it works. So now that for a system where there is so much uncertainty and you have to do so much thinking about how things need to work, and waterfall is just not a viable option. But here we have a couple of lawyers who are obviously having lots of fun testing, and here we have the judges and the court staff who do not look quite so happy, but they were, let's say they were, and of course we got feedback from them, and we had to redesign things. Things needed to change. So, and these are the people who were actually designing the work processes. So for them, it was important also to see what we were doing with their work processes. And maybe they needed to change things in the work processes. That happened as well. So it's a process that goes everywhere. Okay, so once you've got your MVP and it's working, you can start adding features. So, for instance, this is filing a defense by a lawyer. That's one thing that you really need to do. And then we have message traffic between the lawyers and the court, one way back and forth, access to the documents. And what you see here at the bottom of the screen, the gray block, is an API where, let's say, people who use the court a lot, like large law offices, can directly file cases from their document management system into the court system. So that's one. Then, oh yeah, we didn't have a hearing yet. So here we've introduced managing a hearing, like hearing dates, actually the hearing itself, being able to show documents from the case file in the courtroom, things like that. And actually I find the most interesting thing about having the hearing digitally supported by a digital system is that at the end of the hearing, the judge can decide what comes next. So that can be, if there is enough information for a judgment, the next step can be setting a term for a judgment. But if there is not enough information, the judge can decide who will need to provide more information. And if that can be just another document after which the other party gets 2 weeks to react, or another hearing, or presentation of evidence. And you can deal with those things immediately in the hearing itself, so that can actually save a lot of time. And what else did we do here? Oh yeah, this is where it gets interesting. Let me give you the whole story right away. An innovation in procedural law was that that in order to save cost, it was no longer necessary to always formally serve the summons on the defendant. You could also informally inform the defendant that there was a case. But you could not get a default judgment like that, because for a default judgment, you would still need a formal notification, formal service by a bailiff. But and the complication here was that the bailiffs were really worried that it would cost them a lot of business. I don't agree with them, but that was not the point. The point was that the bailiffs were really worried, and they went to the Minister of Justice and they said to the Minister of Justice, if you leave this like this, we are going to make sure that this new procedural legislation will never make it through Parliament. And so the Minister of Justice actually decided to bow for that argument. So about halfway into, we had already designed, let's say, the whole front end, which is where all the security is. And then the legislative proposal was changed in such a way that we had to rebuild the entire front end in a way that was much less secure, but that's what the law said, so we had to do it. And it took us about 6 months extra work. So this, and of course, these things will happen. If you do in parallel, you do new legislation and you build a system, these surprises will come up. So that's what happened there. And technically, what the bailiffs wanted was that they wanted to be able to serve a summons on a defendant without the case going to court right away. So, but that meant that all the security that a defendant would need to actually access a case file, maybe at a later point, would have to be issued by the bailiffs. Whereas in the original proposal, it was issued by the court, which is much more secure. But so it was expensive. It took a long time, and it was significantly less secure. Let me see what else we have here. And of course, oh yeah, finalizing the case. What do you do when you finalize the case? You make sure there is an archived copy. The document needs to be in PDF form, so it becomes unalterable. And it needs a digital signature from the judge. Now, getting the judge's digital signatures was a new thing, and after a while, when the system had been up and running into the two pilot courts for a while, it turned out that you could not trust the digital signature in certain circumstances. That was decided by the Supreme Court. For instance, if you're a judge and you're using one of the available computers in the courthouse, and it's not your own computer, but it's just a computer that you use, you cannot be sure that the person who sets the digital signature is the judge. So that the work process needed to be changed there. So, and those are things you just do not think about those things before they happen, and they happen all the time. So that was finalizing the case. And then when we had the system up and running, it had to go to the pilot courts. We were told that there would be two pilot courts, which in my view is one pilot court too many, but that's what we had to do. Keep it in the beginning. You really have to keep it as small and simple as possible. But this was how we had to do it. So here we have the court in Arnhem, in Gelderland, doing a test case to see if the system would work with the test case. And our technologists didn't like that because they said, you know, they're fake data. So they're going to clog up the system. We don't want fake data in our beautiful system. But we're glad we did that because pretty quickly we found out that we needed to make changes. And the picture at the bottom was when we did a test hearing to see if a hearing could be done with a digital case file. And that went really well. And once we'd done those and fleshed out the difficulties, then the pilot courts were opened up to real cases. And then for the first 6 months, we had one real case. But never mind, that was a very useful case because it gave us a lot of information about things that we still needed to change. So ultimately, what the procedure looks like and how it works is this. You've already seen this. So I can walk through that fairly quickly. Here we have the defendant who is notified, in this case by the court, or by the lawyer, or by the bailiff. And he needs, this defendant is not a lawyer. So he doesn't have access to the case file himself because there was a lot of discussion about the digital signature, the digital identity that we all have been given by our government. But some people thought that digital identity was not good enough to allow people into court. Now, what they had not understood that we were using two-factor authentication, but they were able to actually escalate their problem to the Judicial Council, who then told us that we couldn't give others than lawyers access to the system, which was against the project brief, but still there was nothing we could do about it. So the bailiffs became more important once more, but this defendant is unable to read the case file for themselves, so they have to find themselves a lawyer first. So here we have the lawyer who can then access the case file. and advise the client whether or not to file a defense. And if they don't file a defense, of course, the case can then go to decision right away, because then it's a default case. But if they decide to join the case, and that's what they do here. Now, this is the decision without a hearing. Once they decide to file a defense, the system automatically gives them 6 weeks, a maximum of 6 weeks to file a defense. Now, there are a couple of important things here. One of them is that the system does that automatically without human interference. Why? Because the law says this is what has to happen. And if the law says if an event like this, always event Y needs to happen, you can automate it. So that's we automated all those instances rigorously and said, okay, if that's what the law says, we'll automate it. The other one is the maximum term for the defense. And why is that important? Because now, in the paper world, if you get 6 weeks, no one will actually look at your case file before those 6 weeks are over. But the system will recognize, if you file digitally, the system will recognize that, oh, the defense is already here. You know what? The law says if the defense is here, the next step is X. And the case can then move on much more quickly. And you can gain a lot of time doing that. And we've actually, from the pilot cases that were done, we know that can actually happen. If the parties want to proceed quickly, they can. So at the bottom, we have the communication between the court and the lawyers, which is important for taking procedural decisions. For instance, do you need a hearing? I don't think a hearing is necessary. What do you think? Okay, no hearing. Or, oh, well, if you want to have a hearing anyway, let's do it. So those kinds of discussions. And if there needs to be a hearing, once the defense is in, of course, in principle, there is a hearing, but in a lot of cases, hearings are unnecessary and they are expensive. So hearing planning is there. And if there is no hearing, the case can then go to decision. If there is a hearing, it goes there. There's a hearing. And then, as I explained before, there can be a procedural decision at the end that parties then know right away, and the system can then proceed with the next step. So the system is really important, but it needs to know what to do. And how does a judgment actually come into being? Well, it's usually a back and forth between the clerk and the judge, and they use standard Microsoft Word to do that, and they can do that within the system for as long as is necessary to until the judge says, okay, this is the final version, and then they can digitally sign that one, and then all that needs to happen is that someone in the back office finalizes the case, uploads it into the digital case file, and there we are. And then the parties get a notification that the decision is there. So this is how we delivered the system. It worked in 2 pilot courts. The Ministry of Justice, because they had to invest a lot of money, wanted it to be required digital procedures as soon as possible. So for 2 years, lawyers were required to actually file digitally in those 2 pilot courts. They filed altogether about 4,000 cases. And so we know that the system really worked. But that's not all. Something we did every 6 weeks, we would give demos of the new features that we had added to the system, and the people designing the work processes and any other stakeholder who was interested could come and see what our demo was like for that time. So we added new features, like, of course, video hearings at the time were fairly unusual, and we felt that it would be too much to ask of the courts to make that jump as well. So they've made the jump by now, but we're talking 2015, so that would be a little bit too much. Other things that courts need to do is to publish case law. That's a whole chapter in itself. Smarter searches across the databases could be something. And of course, an issue that we left undone at the time was digital evidence, because that was outside our project brief. So he would. So a few takeaways from that exercise. What I see is that at least in Europe, justice institutions, courts, judiciaries are still moving from network technology to e-platforms, which of course is the phase that we built, where you have a platform to do your procedures on. And there is not a single judiciary in Europe that has gone fully platform so far. And they're all struggling to manage the transformation. And so, of course, the intriguing question is why? Why is that? Another trend is that, and that's of course, it is a necessity, that when you start communicating with your outside users, you also need to pay more attention to their needs and what they can do, their capabilities. So that I can see that changing in the debates that we have in Europe about this. Another thing is once you go down this road, you start a transformation that will never stop, because once you have your system up and running, people in the courts will discover things that they can do with the system that you hadn't thought of, and that maybe they want. And so you have to keep building and innovating all the time based on what people's experience with the system actually is going to be. Once you know what it is, it will never stop. And then of course the big question is, how do you manage all that? So, and to think a little bit more about that, this again, we are back in Strasbourg on June 27, 2018. I had just retired because physically I could no longer commute from my home in Haarlem to the IT systems in Utrecht every day. It was a 3-hour commute, and I just could no longer physically do it. And the system was done, as good as done, and I thought, okay, they can manage without me. So I retired. And officially by the 1st of May. But at the end of June, I was in Strasbourg talking to another commission there about artificial intelligence. And so here we were, and halfway down the morning, I looked at my phone, and there was a message from my team in Utrecht saying that the Judicial Council had decided not to implement the system. Just like that. So there we are. And it was, in a sense, it was my life's work. And what they told me actually was that it was the court presidents who refused to implement. And I can understand why that may have been, because the court presidents were just barely managing the caseload they had. And they were afraid that if they would have to do an operation like this, that it would cause problems within the court. One of the reasons why it would cause problems was because, of course, part of the work that was done by the administrative staff would be taken over by the system. And from day one, the Judicial Council had said that the system was intended to reduce the administrative workload by half. So the administrative staff in the courts, the ones who were good enough, had already left because they could see this coming. But the presidents clearly were afraid for, let's say, upsets in their courts. That was one thing. And there was never an extensive official evaluation like there was on the other projects. But there is a letter by the Judicial Council to the Ministry of Justice to explain why they decided to do this. And these are the reasons for that. So reason one is that the level of ambition was too high. Now, this is a common risk with technology projects, that the risk is that its ambition is too high because you not at all. The judiciary governance is too complex. Now, what that may mean, I've spoken to a lot of people about what actually happened there, and what it may mean is that there was no clear division of competences between the Judicial Council and the President. So they were unsure of each other, of who was actually in charge. And the Judiciary IT organization, is it part of the judiciary, or is it something, an organization that you can outsource something to, and you can then, punish them if they don't do what you want? Or do you have to practice solidarity with them because they are part of you? That was another unclarity there. And I think these were lessons that have partly been learned, I think. Insufficient framework and management architecture. I've never recognized this one, I must admit. But this, of course, it relates somehow also to governance. And the important one, insufficient capability for agile organization. So there we are back at the legal culture, which finds experimentation and innovation very problematic, because it means you can't blame somebody for something that goes wrong all of a sudden. That's what happened there. And so when I was making this presentation, I was thinking, okay, what shall I do? In 2009, those were my findings on the right. And this is what we know in 2018. And something else that is actually not here, and I never realized that I already said that in 2000, what was it? 1998, that who needs to be in charge of decisions about about procedures and about what the technology needs to do in those procedures. It needs to be the people who are in charge of the procedures. And that is not the Judicial Council, it's not the Ministry of Justice. It is, for instance, in our case, the expert group on civil justice within the courts. They have a national expert group. They should be the ones actually owning the procedures. But that is a step that the judiciary still has to make, and I'm not sure they will make it anytime soon. And I was surprised that I already said that so long ago. So in 2009, I said new governance may be needed. Well, clearly, the Judicial Council itself found that its governance was ineffectual, didn't work the way it should. So what they've made a change, and they have delegated their decision-making powers to councils within the organization that are in charge of making decisions about one that can make decisions about the plan, and then there's one that can make decisions about the design, and then there's one that is actually in charge of implementation. I've asked them, does it work? And they said, well, it's still too early to tell if it works. So, and here again, not exceptions. What we found was that when we were testing the system with court users, they would say, oh yeah, but about every once in a while we have exception X, and you haven't programmed it. So we had a discussion about exceptions, and with the work process team, we agreed that we would not support anything that happened in less than 4% of all situations, because otherwise, that is the 80% that you do not want to do. But that is also, it's very hard, because we lawyers are very much geared to making sure that all the exceptions are taken care of. Let me see. So. Okay, let's leave that here. And yeah, for now, that's what I thought of when I was asked to come here. And so I've shared really my personal story about what happened. And make no mistake, it was a lot of fun. I had a wonderful time with a great team, and we did lots of very interesting work. And even though the system has now been closed down, I still see it as my responsibility, or let's say my role, to keep sharing the information and the experience that we learned from it, because we learned so much that could be useful for other judiciaries who are trying to do the same thing. So that's why.